As all of CPAN's members know, the Michigan legislature is considering a bill that would drastically change, basically eliminate the Michigan no-fault system as we know it. Central to that bill is the elimination of lifetime medical care. And the argument is we can't have lifetime care anymore because it's going to break the system down the road, financially break it. We have to cap these benefits. And so to get to the bottom of that, CPAN submitted information requests under the Michigan Freedom of Information Act to the Michigan Catastrophic Claims Association, who is the proponent of this argument that the system's going to fall apart. And we asked for certain specific information dealing with closed claims and open claims that gets to things such as the age of the claimant at the time of injury, the age of the claimant at the time the claim was closed, the total amount paid at the time of closure, the total amount paid to date with respect to open claims. And we believe this information is critical to enabling the legislature to really look and see, is it true that we can't have lifetime medical? Or is the data being interpreted incorrectly? And regrettably, the Michigan Catastrophic Claims Association said no to our Freedom of Information request. They said that they were exempt from having to comply because of some strange little obscure law that was passed in 1988, allegedly giving them a FOIA exemption. And when we got wind of that, we consulted with Professor Noah Hall from Wayne State University, who is very knowledgeable about FOIA. He assured us that, in his opinion, we were on the right side of this issue, and so we asked him to help us out, and he's here, and he has a more specific take on the actual FOIA issues here.
Sure. So, the Freedom of Information Act is one of the most important tools the public has to hold their state government accountable. It entitles any member of the public to request information from a public body, and those public records need to be provided on certain time frames and at minimal costs to the public. When MCCA claimed the exemption, they cited, as George mentioned, a statutory provision that had nothing to do with the Freedom of Information Act. It's buried in the back of the insurance code at 500.134. It was the result of a bill that was passed in 1988 that exempts the records of the MCCA from disclosure under the Freedom of Information Act. The problem with that is that the Michigan Constitution, Article 4, Section 25, requires that the legislature, anytime it's going to amend, repeal, or otherwise change a law, needs to recodify the law itself. You can't go and change a law by sticking the amendment somewhere else in Michigan's thousands of pages of code. You got to change the law itself if you're going to make the amendment. The legislature didn't do that. Instead, they passed this amendment, buried it somewhere in the insurance code, and to this day, when you go and look up the Freedom of Information Act and look at the records that are available as well as those records that are exempt, you'll see no mention of the MCCA or their insurance records. The law is absolutely unconstitutional, and denying a FOIA request on the basis of the unconstitutional law will be rejected by a court.
And the other point here that's very, very significant, we've encountered a number of legislators who are truly bothered by having to make such a significant decision without having all of the data available to them. And by taking this step, by filing this lawsuit, we reach out to them and all members of the public who are interested and say to them, help is on the way. Don't make precipitous decisions about things that are so important to the health and welfare of the state of Michigan unless and until you have all of the facts at your disposal. And hopefully through this lawsuit, we will get the facts that the legislature and the public needs to make a sound decision regarding this issue. It's our money. It's our money. We pay premiums to our insurance companies, and a specific amount of that premium is segregated as the MCCA surcharge, and it's about $150 per car, right around that. We don't have the right to say, well, I'm not going to pay that. I don't like that. That MCCA surcharge is too high. We can't withhold that and send in the rest of the premium. If we do that, we haven't paid our policy. We become uninsured, and then we become subject to the criminal sanctions of the no-fault law, which include going to jail for a year if you don't pay your premium.
So they make us, in essence, pay this money. And it goes to the MCCA, and they manage this money and pay the claims. They are managing our money that we have been forced to give to them on the pain of potential criminal violation. And we say, look, in that scenario, you who have been created by the legislature are a public body managing our dollars. We have a right to know what you're doing.